Good morning. After a long time, when I went to High Court, I witnessed some young advocates are very eager to file quash proceedings, but they are not equipped with proper citations and where and when to argue about the sustainability of the quash proceedings and what all are the citations are most important. Therefore, today I want to interact with that subject. Number one, this 1898 CRPC Colonial Act initially did not contain the power of the High Court to interfere with any mistake committed by the lower court. Therefore, the very British government brought an amendment, Criminal Procedure Code Amendment Act 1925. Then they say that for three purposes, or 480, that inherent power may be exercised by the High Court. Number one, to give effect to the order of the lower CRPC provisions. Then to prevent the abuses of the process of the court and to secure ends of justice. This was the history of CRPC. Then first case was R.P. Kapoor versus State of Punjab, AR 1960 SC 866, which discuss about the powers of inherent powers of the High Court. Then they say the ex debito justilii. This means to do real and substantial justice, these inherent powers are there. Then if you want to challenge the 107, 109, 110 CRPC proceedings, the main ground should be the order passed by the executive magistrate was cryptic and non-speaking order, or with some violation of the provisions. That case is M.N. Oza versus Alok Kumar case. Then you see one maxim, quando lex aliquid aliqui concedet concedere viduret id senacio res ipse essa non potest. Maybe probably practically may not be, but you should know this also. The maxim says, if law gives anything to anyone, it gives also all things without which they think itself would not be unavailable. Therefore, if you have some right, but to exercise that you want some other facilities also, unless that facilities are not given to you, the given right is unavailable. This is what this maxim says. Ex debito justice, to do real and substantial justice. Then you see B.S. Joshi versus Haryana, State of Haryana, 2003, Part 4, SCC 675. This judgment may be applicable for non-combustible offences. If compromise is affected, may be quashed. This is Supreme Court judgment. Our High Court judgment were a lot of that. Then the teachers' negligence. Nowadays, the teachers are made a scapegoat if any student commits suicide. That they say that one case it was quashed. That is Vijay Lakshmi as a State of Tamil Nadu, 2013 3 MLJ Criminal 463. You go through the judgment and at last paragraph when judges quashed the complaint itself or FIR, what are the discussion? By going through that discussion, you can work out grounds by similar type, by applying your mind. Then malicious complaint. If allegations are so absurd that no reasonable man would accept the same, the complaint may be quashed. This is what Maror Maharaj Prasad Kaitar versus Ram Gopal Podadar, 2011 1 MLJ Criminal 128 Supreme Court. Yesterday, a woman advocate was arguing that the FIR, the allegations are false and other things. She would have referred the judgment and they would have stated grounds in conformity to the discretion of the learned judge in this judgment, so that she can substantially draw the attention of the judge. Judge was very accommodated. Civil dispute criminal case may be quashed. To get over with the civil dispute, the criminal cases is filed. That is P. Kaliyamurthy versus State 2013-1 CLT Criminal 488 Madras. Then to quash the FIR may be quashed if allegations are not there for cognizable offence. It should be rarest of rare cases. That was quando dicut mandatus et omne per quad perventure ad elude. When in command, somebody is in command, his command should exercise cautiously and sparingly and with circumstances. That is Kasimayan versus Kasimayan versus Inspector of Police 2002, MLJ Criminal 226 Madras. Then to State of Orissa versus Kumar Sahu 2006 to SCC Criminal 272. If you are challenging sanction may be challenged by if the sanction was not accorded by competent authority. If sanction was accorded without application of mind, it may be quashed. So these two grounds should be there apart from all your grounds. Ravi Kumar versus Tamil Nadu 2012 Part 3 MLJ Criminal 368 Madras. For change of investigation may be ordered even suo motu or even after disposal of the appeal. That you can also apply this judgment. This is unreported judgment, State of Punjab versus Darinder Pal Singh. Appeal numbers were given. Then prayer for proper investigation, seeking medical board report. Suppose if you want to be special medical report, this judgment may be applied and you can file application to 482. Yes, Mahavir Shivaji versus State 2013-1 CLT Criminal 389 Madras. Then even after filing final report, you can seek for further investigation. That is Amit Bhai Antachara Shah versus CBI 2013 Criminal Law Journal 2313 Supreme Court. Then finally Arul Shankar versus State of MP, Criminal Court may not change or vary its own order 2018. So for your sake, I will cover this. Probably how could you understand my handwriting? I can't help you because this is my slowest handwriting. Now I want to discuss something extraordinary. What is happening? This what had happened when the present government earlier also, because they happens to be an independent experts. They are several experts are being appointed whenever DMK government rules. Unlike the other governments, I can simply say that what happens, earlier an order was passed by Justice P. Velmurugan. A fantastic order. Every defense lawyer, after wide publicity, newspaper, happy that the summons and warrants which is sent to the police stations are not being executed, and periodically 482 petitions are being filed. So in the given case, not that in the given case judge has got annoyed after having sustained the lethargic attitude of police officials. He have passed an order stating that for inaction on the part of the Inspector of Police, who could not execute the warrant. He said during those periods his salary should be recovered and deposited to the treasury. That was the order passed at 2021. Surprisingly, that matter should be reposted only on compilation of the report, the compilation of order by tag end of the February. But that case was listed yesterday. There was no petition to set aside that order or vary that order. How the additional public prosecutor and police officials are influencing the registry, and registry simply listed that case. That grievance I have, and that matter is now posted to 23/2. I could not understand that this is a somewhat judicial indiscipline. Attempt was made to distract the judicial discipline, because the final order was passed by Justice Vel Murugan, and the additional public prosecutor wanted to get away with the order before the other judge. This would be, I want to bring to all of you this judgment. I can't leave, because not just like that, even though, and the police officials instead of executing the warrant, finally they facilitate the accused to get non-bailable warrants be recalled. And the additional public prosecutor, instead of arguing for the police officer who was punished, he is totally arguing for the main accused who are absconded to quash the proceedings. Somewhat that type of argument was there. This should be kindly checked by this present government top officials, Advocate General and other things. To anybody, kindly place this communication to him what had happened. Best wishes.